Hello, YouTube. I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. It's Saturday morning. And I just found out that late tomorrow evening, I gotta go to work. Not here in New York. So I gotta crank out a couple of videos for the next couple days, which I'm gonna do right now. Because we got a question from YouTube user Country Boy. Thank God I'm a country boy. Actually, listen, good song. But also, the way the world is currently going, I am pretty thrilled to be able to live in the middle of nowhere. Things don't seem to be going awesome these days. I will say that. YouTube user Country Boy asked us, please make a quick video to this. What is the point of a jury trial if the judge still makes the final decision? Now, Country Boy also asked us an additional question, which I think was related, in which he asked, judges or the jury, which one should we choose? Because at the end of the day, the judge still makes the final decision. All right, Country Boy, let me clear this up for you a little bit. Let me give everyone a little bit of context as to what I believe Country Boy is referring to. If you go to jury trial, we'll just limit this to federal court. If you go to jury trial in federal court, although I think it's certainly true in state court as well, depending on where you are, this and that, there's always, listen, I can't tell you everything that happens in every state court in the U.S. I can only speak to the state courts really of New York in terms of what I'm experienced in state court. But if you're in federal litigation and you have a workplace discrimination or workplace sexual harassment case, and you embrace all the risk of trial, all the risk. You go to the big show, you make a federal matter of it, you get your trial, you have your day in court, and you win. And then likely that was a bifurcated trial, so you win or you lose, and then you have a second part of the trial, which decides how much you win. And let's assume you won your trial and that you had a jury trial and the jury gave you $50 million. And that's awesome. That's super exciting. Excuse me. But what Country Boy here is referring to is the fact that the judge might say, okay, jury, I respect that you found for the plaintiff. That's good because you're the finder of fact. You're the decision maker here. But when you assign those damages, you failed to apply the law. Like the law has very specific ways that these damages are calculated. And we've got a playlist on the channel about how kind of explaining that, right? And you, the jury, departed from that and assigned a number that can't be substantiated by those formulas to the damages here for the plaintiff, right? You assigned the plaintiff in this hypothetical $50 million. And if you do the formulas, we're not getting to 50 mil. It just can't be, right? And so Country Boy is saying, well, hold on. What is the point of a jury trial if the judge can do that? So, a couple things. One, juries, if handled correctly, and that's a big if, it's a huge if, but if you select a really good jury and you have a really good jury pool, and you put on the show, the theatrics, the pizzazz, right, that a jury needs to see to find for your client, you might have more success swaying a jury with a really well-done trial than you would have swaying a judge or an arbitrator, right? Like I routinely sit as an arbitrator. I arbitrate employment cases, meaning I sit and decide them in place of a judge, right? And attorneys are going to come out with some really lovely presentations, and I will listen to them with a neutral mind, right? I will keep an open mind and listen But when you're putting on the pizzazz, I'm sitting there like, okay, but like, can we get to the elements of this claim? Like, did it happen or didn't happen? Did we meet the elements? Did we not? Right? And they're like, look over here, judge. Ha ha. You're like, yeah, that's not a thing. That doesn't matter. And I'm getting worried, a counselor, that you may not know what you need to prove for your own case, which is the classic failing of a pro se litigant or a young, inexperienced attorney in this field, right? Like that is the core There's a lot of other things that go on. There's a lot of ways that you can move the needle in your favor or against yourself. The core thing is, did you prove what you need to prove? Which is what every pro se litigant generally just can't wrap their head around. But look at all the things! Yeah, none of those things are what you need to prove, right? Like, did you prove the things you need to prove? So with a jury, they're not really quite so married to the idea of what you need to prove, right? There's a lot of feeling. I feel like they proved their case. And that can be a beautiful thing, because that's where good lawyering gets done, right? Like, listen, there's cases that everybody knows is going to win. Never guarantee, but everybody pretty much knows that case is going to win. There's cases everybody knows that case is going to lose. That case is bad. That case isn't what the plaintiff said it was. Turns out things were different, right? That happens too. And listen, the worst case can win and the best case can lose, and that's just nature of the field. But you pretty much everybody knows. If you run that case 10 times, it's losing 9.5, right? Like, realistically speaking. Where the magic of a jury comes in, so you got a case that maybe it loses 7 out of 10 times. But the facts are a little salacious, a little dramatic, a little a little hint of the holy shit, right? You might be able to move that needle with good lawyering, good trial presentation, from you lose 7 out of 10 times to it's a coin flip, 50-50. We don't know. We could win, could lose, but like it's way better than it was before this trial started. That's for sure, right? So that's one of the huge advantages of the trial, of the jury. I apologize. The next thing I'm going to say, I'll give you, before I move on, example, you're trying a case in the Bronx, in state court. So you got a pure Bronx jury. Defense counsel come in. I don't think you can prove this. I don't think you can prove it. Sure. Yeah, I don't agree with that, but what are we talking about here? Defense counsel, what do you mean? You can't prove your case. I'm like, I think we can. But we are in the Bronx, and the Bronx jury is going to tell you to go fuck yourself. Like, this is not a population who's really eager to see employers shitting on employees for a variety of reasons. Socioeconomic reasons, historical reasons, just the basics of like how the average juror in the Bronx has been treated throughout his or her life. Like, there's a lot of reasons why they might think you, as employer's counsel, are an asshole, and so is your client. So I suspect you're not going to push this case to trial, are you? Because we're in the Bronx. We're the Bronx jury, right? So that's a valuable thing, and that exists in many parts. There's also reasons why, like, listen, there's jury pools where you're like, not a good jury pool, right? It's not a good jury pool. It just, if you're living in an area where everybody from your jury pool really likes marching with tiki torches, I don't know if you necessarily want to try a racial discrimination case with a local jury pool. You might look at your options to get a more diversified jury pool. I suspect, right? If people love white hoods in your locale, it might not be the best locale for your jury to be pulled from, right? So there's also disadvantages. Like, if I was legitimately trying a case in like a heavy Klan area, judge, bench trial. Yeah, get that judge. I don't need a jury. Like, you're telling me I can get a judge from a federal? Yeah, that's not from here. So it's a federal judge from another part of the country who's appointed for life. Yeah, I'm gonna go with that, right? Like, that's like there's always considerations. You're always making this like totality of the circumstances based strategy that you're cooking up, right? And that's part of what the attorneys do in this game. So, there's a lot that goes on with when you would want a jury and would not want a jury. And there's a lot of reasons why a jury is valuable for that first part of the trial, the part where you win or lose. Now, don't get me wrong, though, the jury can be really valuable for the second part of the trial as well. One, if you educate your jury correctly and you give the right jury instructions and you're really clever with what kind of resources you're able to put at their fingertips, you could get a really sizable verdict that utilizes the correct calculations of the law. And that would potentially be larger than a judge might give you, because judges are going to be a little bit jaded some of the time. Whereas a jury, they've really only done this once, right? I always use the example when I'm talking to people like administrative law judge. Like if a lot of my peers will become like administrative law judges, right? And that means they just hear specifically, a state agency often, these kind of cases, workplace discrimination, workplace sexual harassment. And that's it. Day in and day out, they're 5 days a week hearing these trials. And before that, they had a lifetime of practice just like me, where they were attaching dollar values, either as defense counsel or plaintiff's counsel, to these cases. Excuse me. And all of that leads to them having a wealth of knowledge about these claims and how they're proven, and that can be very valuable in complex cases. It also leads them to have predisposed notions and a jaded outlook on how damages are calculated in this field, because they know during their career about what they got for their clients on a given case that looked a little bit like the case that's in front of them right now, right? And a couple things happened. One, time has marched on. Inflation happened. And the human brain, when it says, oh yeah, this kind of case gets 100K, it doesn't necessarily apply the fact that groceries are 30% more now. What was 100K 5 years ago, depending on which economic inflation index you believe, could be somewhere between 109 and 135K today, right? In terms of buying power. So I'm not trying to get political with that. I'm just saying the economists don't seem to have a lot of consensus on how to calculate inflation. And the government uses some inflation indexes that are really good for the government. And then other people use inflation indexes that are really good for them. And I'm not an economist, so I don't know who to believe, right? Now, there's a variety of reasons why. So you might want a jury to do that, because this is their hopefully first time deciding an employment discrimination or employment sexual harassment case, right? They're not jaded. This is their first time here, and they're saying, holy shit, the stuff you're describing is terrible. The horrible things were done to your client. I hope we can help them. Let's help them big, right? Like a case I worked on, God, more than a decade ago. I can remember I got to talk to the jurors after the trial, and there was this little old lady who all the jurors were like, yeah, so we actually wanted to give your client less, but that lady over there wouldn't let us during the jury deliberations. And I went over and talked to her. I was like, well, yeah, thank you so much. What caused you to give, what caused you to push so strong for the larger monetary damages? And I'll never forget. She looked me dead in the eye and she said, I told them that's not money. I mean, I'm not going to do the accent, but it was like this really cool accent. And she just was like, that's not money. That was her take on it. She's like, that's not nearly enough. Right? I mean, she simplified it, certainly, but like, what a soundbite. That's not money. I would still invite her to Thanksgiving. Like if she had interest in my cooking, she has a permanent invite to Thanksgiving. Like fantastic juror. And I believe probably a fantastic human being, right? So that's good. And you get these big numbers, which hopefully are in the formula, calculated in keeping with the law. But if they're not, you still have an anchoring effect. So we'll go back to our 50 mil, right? Let's say in that case where the jury gave you 50 mil, gave the plaintiff 50 mil, the actual damage calculation might have been like 1.8 mil. Like realistically speaking, with the damages at hand, and let's just say no punitives in play, a realistic calculation would have been like 1.8 mil. Now, there is some leeway there. There's going to be some interplay between the federal calculation and if you've applied state and local laws in your federal litigation, the way damages are calculated in those laws as well. So there's a lot going on, right? There's potentially up to like 15 different laws in play, and all of them could have slightly different calculations. So if you get this jury who says 50 mil, right? You're like, oh my God, thank you for your jury duty service. You're fantastic. And defense counsel is going to be like, you're not going to defend that 50 mil. I'm going to try. Like, every step of the ground, we're going full Ukraine. We're digging the trenches. We're going to defend every inch of ground, right? So we try, right? We try to defend that. We will die on that hill. And in part of dying on that hill is that you put up this big fight and you try to get the judge to not reduce it by as much. So whereas a reasonable calculation might have been 1.8, sometimes you see the judge reduce it if you really do a good job in that fight, in that argument. Sometimes judges don't want to push it too far, and they'll be like, well, I do respect juries. And if you give it the best possible reading of how they calculate the damages here, you could theoretically fudge the math to get to like 4 mil. And I don't really want to be appealed. I mean, I know I'm going to get appealed because this is an employment case and there's a huge verdict here, so defense counsel is going to appeal. But like, I don't want to be overturned on appeal. And it's a bit risky. It's a bit risky substituting the judge's judgment for the jury. It's not, it's not like a super awesome part of our system. Because one of the conceits of our system is that the jury decides. They're the finder of fact when you ask for the jury trial. When you're substituting the judge's knowledge and judgment for the finder of facts, the jury's knowledge and judgment, that's a bit of a like bait and switch. And the system is aware of that. They're also aware that juries don't know how to calculate damages because we develop wildly complex laws that people fight about for the 40 years of employment law that have been going on now. I mean, theoretically 70 years, but like 40 years of like real heavy practice. And, it's not the best look. So the judge is aware. There's going to be an appeal because defense counsel will try to appeal. And they also want to delay payment, right? And we'll talk about that in a second. So you could have this anchoring effect where the judge tries to give the jury the best possible reading of what they put down, what their decision was, and you get much higher than the judge might have put together on her or his own self, right? Like, judge might be like, yeah, so you win. Calculated damage is probably realistically 1.8. Give you 1.8. Okay, we're done, right? Now, listen, there still might be a fight about that. Defense counsel still might appeal, not because they necessarily disagree, but because they don't want to pay right away, right? But realistically, there's a really good chance that judge might feel anchored by the jury up here at 50 mil and might say, okay, I know 1.8 is probably the right number, but I'll give you 4. And that has value too. Now, the last piece of value, which we've kind of already hinted at, is when you win a case at trial in this field, and you win big, right? I'm not talking like 300 grand, which happens. I'm not talking winning somebody 50 grand, which happens. But when you win somebody in the 7-figure range, you pretty much know what's coming. An appeal. Why? Because one, defense counsel doesn't want to go down without swinging, and they get to bill by the hour. So if they do an appeal, that's maybe 100, 200 additional hours of hourly billing they get to do at $1,600 plus per hour. Why would they not? And part of their pitch is to their client, hey, we could probably get this reduced even further, on appeal, if we do the appeal. So you could spend, maybe like 100, 200 grand, but we might be able to knock out 2 mil of this, maybe 2.2 mil of this in this hypothetical, right? Because the actual number that this person should have won is probably 1.8, but the judge gave them 4, right? So that jury, I don't know. They messed up big. They went 50 mil. We got to look at that. Maybe there's something going on there. Maybe something's wrong with that jury. So we'll look at that too. But also we're going to look at this judge's decision on appeal. Given 4 when it should have been 1.8. So, you're paying us a couple $100,000, but we could knock out 2.2 mil here. It's a hell of a pitch. And also, while we're at it, we might add a couple of years before you have to pay this. And not for nothing, we looked into that plaintiff a little bit, and that plaintiff doesn't have a lot of money. And that plaintiff does happen to have a sick mother and starving children. So that plaintiff might need money now. They might need money now. So, they won. Now they won 4 mil as it stands right now. But we could probably, as time marches on, twist the screws on that plaintiff and offer less, maybe even less than 1.8 mil. Maybe if your mother's going to die without the treatment she needs, and that treatment costs $300,000, well, you know what? We could offer $300,000. We could offer 4. Why not? We already lost 1.8. Why not offer $400,000, right? And they might take it because they might need money today. And realistically, nobody's going to give this client $300,000. Probably not. But we could get rid of today 4 mil or 1.8 mil or however you want to look at it in a verdict against us just by making this client wait a couple of years. And their attorneys will beg them not to take that. But their attorneys don't have 6 mothers who need treatment for $300,000, right? So you got this appeal coming, right? And that appeal's dirty and ugly, and it's going to be nasty as all everything, right? But while that appeal's pending, what do the plaintiff's counsel get to do? Well, we're already doing an appeal. We're opposing defense counsel's appeal. We got to defend our verdicts. We're opposing their appeal. But while we're here, spending hundreds of attorney hours defending our verdict, why don't we take a little stop and say, that judge exercised improper authority by reducing that jury's verdict. The jury was the finder of fact. And we have some arguments as to why that jury's verdict should have been upheld for 50 mil. Are those the best arguments? Do we think we're going to win those arguments necessarily in front of appeals court? Really depends on the details, but most of the time, no. We don't think those are high percentage arguments. We don't think those win 99% of the time. That number's not real. Listen, I think maybe you can, these numbers are kind of meaningless, but it's like a 70% argument. You maybe lose it 70% of the time, but you win it 30% of the time. The judge shouldn't have overridden the jury there. Jury wasn't as bad as the judge said. Jury's reasoning was sound if you read it the way we want you to read it, and that jury should have been respected. The jury's the finder of fact. That's the whole system. That's the whole conceit of the system. You're messing with justice, judge, and appeals court. And that's an argument. Listen, it's not the best argument. It's not like a sure thing. There are no sure things in this field. But it is an argument that adds a risk to this endeavor that defense counsel has embarked upon. Real risk, tangible risk. And now they got to go tell their client, okay, so we did tell you we were going to spend $200K litigating this appeal and that it was probably going to, maybe reduce your verdict by 2.2 mil. What we forgot to tell you, what we didn't know was going to happen, is that plaintiff's counsel is actually, they got their own appeal going. And it's going to pen as long as our appeal pens. And their appeal is that you should actually be paying 50 mil. And listen, we don't think they're going to win. But I did mention there's no sure things in this industry, so we can't tell you they're not going to win. So the thing that we're doing, this appeal, where we're trying to drown this client in debt and make them take a bullshit settlement, or at the very least reduce a $4 million verdict to $1.8 million in our hypothetical, it does now actually expose you to the risk. And the appeals court could honor that original $50 million verdict. So listen, we don't think that's going to happen. But in this endeavor where we charge you $200,000 to reduce this verdict by potentially 2.2 mil, we have exposed you to the risk of increasing that $4 million verdict to 50 mil in this hypothetical, right? And we we can talk you through that. That's not a real concern. But tell you what, that CFO is not going to hear at the company, at the employer. They're going to hear, wait. Tell me what? You're billing me $200,000 to potentially save me 2.2 mil. As part of that, you're exposing me to the risk of an additional, what is it, 46 mil in liability? CFO doesn't care about anybody involved. CFO doesn't care about the person who did the bad thing, probably doesn't care about defense counsel, doesn't care about plaintiff's counsel, doesn't care about the plaintiff. CFO is doing dollars and cents. That's what CFOs do. That's what she's there for, right? CFO says, the fuck are you talking about? Defense counsel, you're exposing me to 46 million in risk when this could be done at 4? Get me a fucking payment plan. What's wrong with you, defense counsel? And that's also a countervailing issue in this, right? Like there's a lot of things going on, and listen, there's so many moving pieces. It's part of why I often say that pro se litigants are just, it's not going to happen. Like 99% of the time, it's not going to work, right? Which is a bummer. And also, like, it's a bummer because I produce some content to help pro se litigants, and like I know when I produce that, like they want that help, and it might help them get to a better settlement, but some of them are like, I'm gonna have my day in court, and that's probably not gonna work out, right? But also I say that, but there's YouTube channels for people who represented themselves and were successful. So it's easy to say 99% of the time I don't think pro se is gonna work out. But even if I'm right, there's still 1% of the time that it does work out. And those people deserve help. You help 1% of pro se litigants. That's actually a fairly decent number of people. So that's a worthwhile endeavor, right? People can give me shit trying to help pro se litigants. They're like, you're fucking those people because they don't know that they won't be able to do the thing because you're misleading them to think that they can do it by giving them help. And it's like, listen, you can't assume people don't have what it takes, in my opinion. I do heavily suspect that most pro se litigants do not have what it takes, but I don't assume it. Those are two different things, right? Some of the people who watch those videos are going to go on to sizable settlements and victories and wins, and that's a good thing. That's a valuable thing. I also think part of the criticism I get is from attorneys who are like, why are you helping pro se litigants? They don't have to hire attorneys. They're getting way less money because they didn't hire an attorney. All true. But they weren't going to hire an attorney anyway. Like when you talk to the people, like there was a guy posting on the channel recently who was like, oh God, these attorneys want a percentage of what they're going to win for me. These assholes. Like, okay. So that guy's not going to hire an attorney because that guy doesn't believe there's value in hiring an attorney. He was like, well, they're not going to get me X amount percentage more. So why would I hire them? That person does not believe the attorneys have value. So they're not going to hire an attorney. I guess you could say, well, I'll spend my time trying to convince that guy. But I'm not into that. I'm of the mind like that guy. Like, listen to that. That guy's not going to believe an attorney because he doesn't believe attorneys have value. But the case still has value. Whether he thinks attorneys have value or not. The case still happened. He was still wronged. He still experienced workplace discrimination, workplace sexual harassment. So, it's still a good thing if the case gets brought, is my take on that. But anyways, Country Boy, I digress. I went through a bunch of reasons why I think the jury has value to the plaintiff. It was a bit of a winding. I mean, we're going on 30 minutes here. So, this is a lot. It's a lot. But I hope it's helpful. I assume there may be follow-up questions. I will track the comments down below for follow-up questions. I'll try to make follow-up videos. If this was helpful, like, subscribe, comment down below. Share the video. It helps me to help more people just like you. Take care.